We'll be live in 5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. Good afternoon to the attorneys. Couple of things before we proceed. You will present the argument as if you were actually in court, except you will not need to stand to do it. Also, if there's any technical matters developed, you will need to let us know immediately so they can be corrected. It's my understanding there's going to be multiple parties arguing. Or the appellant, who's going to be arguing?
I'm sorry, I missed the very last part of that. I had a little glitch in my receiver.
For the appellant, who's going to be arguing?
Yes, thank you very much. My name is Scott Hurley. I'm the attorney for the appellant in this case. I'm a member of the Knox County Bar. This case is...
Ms. Hurley, are you going to be the only appellant arguing, only party arguing? Okay. Have you reserved your time?
Yes, I have.
It's on my understanding you're going to have a total of 20 minutes. Is that correct?
That is correct.
Okay. Now for the appellee, who's going to be arguing and how much time?
Your Honor, this is Seth Friedman on behalf of Sentinel Insurance Company, and I will have 7 minutes.
7 minutes, okay. And who else?
My name is William Sims, and I represent American National Property and Casualty Company. I'll be going second, and I will have 7 minutes.
7 minutes, okay. Mr. Sims, okay.
And I'm Mark Kinsman. I'm representing Steve Harden. I'll be arguing third, and I'll have 6 minutes.
6 minutes, okay. Okay. Now we've got the time set then, okay? The appellant, how much time are you going to have for rebuttal?
We would like to reserve 5 minutes for rebuttal, please.
5 minutes for rebuttal, okay. Okay. And if there's nothing further, Mr. Clerk, will you please call this case?
Vanquish Worldwide LLC versus Sentinel Insurance Company Limited et al.
Okay. For the appellant, you may proceed, please.
Thank you, Your Honor. I am Scott Hurley, a member of the Knoxville Bar. I represent the appellant in this case, and may it please the court, we're here today on an appeal out of Blount County Circuit Court in Blount County, Tennessee, pertaining to a summary judgment dismissal of claims brought by the plaintiff alleging negligence and negligent misrepresentation on the part of an insurance agent who was found by the court to be an agent for 2 insurance companies. The agent was representing American National and a separate insurance carrier that is identified in this case as Sentinel, also the Hartford. At issue is a claim of negligent misrepresentation related to certain statements that the agent made to the insured at a time when the insured was purchasing a policy, and then multiple representations that were made after a claim arose against the insured. The representations that are the central focus of the issues in this case are generally contained in findings of fact 83 through 92 of the appellate record. And in very brief summary, what the court found is that the agent represented to the plaintiff that the plaintiff had coverage for bookkeeping and administrative type work that the company was doing on contractual matters related to United States Department of Defense contracts in Afghanistan. Further represented once the claim arose that there was coverage, that the plaintiff should not worry, and that the defense costs would either be covered or reimbursed at the end of an arbitration proceeding. These findings of fact made by the trial court were based on assertions of fact by the plaintiff in our summary judgment papers, and either the absolute admission or non-comment essentially by the defendant as to those facts in the papers of the agent in this case. And essentially the court found all of those facts to be true. The court went through an analysis in its opinion, which found that there was no coverage here, and coming specifically to the things that we appealed in this case, which is the negligence and the negligent misrepresentation, the court essentially found that causes of action for those two claims could not lie because essentially the plaintiff was found not to have reasonably relied on the representations made by the agent. In this case, the court did so without making any specific findings on the one element that it seemed to focus on, which was that the plaintiff was the president of the plaintiff, whose name was Eric Barton, was allegedly a sophisticated businessman, that there was no coverage under the policies as written for the claims referenced, and that the plaintiff's president, as a sophisticated businessman, could not possibly have reasonably relied on any assertions that there was coverage for the underlying claims or that there were any costs of defense available under the policy once the plaintiff had incurred claims in the administration of the contracts. The crux of this matter from the view of the plaintiff appellant is that the trial court engaged in no factual findings and made no factual findings to support the basic assertion that the plaintiff could not reasonably rely on the findings on the statements made by the insurance agent in this case. We respectfully believe that the law in the state of Tennessee specifically provides that issues related to reasonable reliance and whether or not an insured has reasonably relied on representations made by an agent is almost essentially a factual finding that is to be determined by the trier of fact. We have cited in our brief the elements of negligent misrepresentation and negligence on the part of an agent and the requirements thereof. And then we quoted and set forth in very specific terms the case law in the state of Tennessee regarding findings of misrepresentation and negligent misrepresentations, and a multi-factor analysis that the courts have provided to assist in a determination of whether reasonable reliance occurs. There are 8 of those, and we have cited those in our brief, making reference to the Goodall case, the Pitts case, and the Allied Sound case, and essentially multiple of those factors would have mitigated in favor of the plaintiff. The court, and have I lost my video?
Lost your video, but you still have your audio.
Okay, thank you. The court seemed to focus on only one of those factors in finding that the president for Vanquish Worldwide was a sophisticated businessman, and concluded as a result that there could be no reasonable reliance upon the representations made by the agent, number one, and number two, that as a result of the failure of reasonable reliance, that all claims made by the plaintiff as to the agent, who was the person who made the misrepresentations that are admitted and factual findings by the court, but also the companies which the court found the agent to represent. All of those claims against the companies and the agent were dismissed as a matter of summary judgment based on the court's determination that there was no reasonable reliance.
Mr. Hurley, I'm sorry for interrupting, but didn't your client have an obligation to read the policy and know what was in the policy? That's question number one. And question number two is, ultimately, this court found that the allegations that were made against your client were not insurable. That the proof was there was no policy that would, sort of like insuring an intentional tort. No one's going to insure you for a breach of contract. It'd be one thing if this was errors and omissions, or somehow you were negligent in bookkeeping and there was a claim related to that, but that's not what this case was about. So what do you say to those issues?
Well, what we say to those issues is, if you look at the policies that were part of the record in this case, they're very long, complicated policies. We certainly concur that Tennessee case law does provide that an insured is responsible and chargeable with knowledge of what is in the insurance policy. In this particular instance, the discussions that occurred between the insured and the agent about the policy which occurred before the purchase of the policy and before the receipt of the policy, were along the lines of the insured providing the agent with a tremendous amount of information. And again, that's a finding of fact made by the trial court about what the plaintiff did and what the plaintiff appellant was looking and seeking coverage for. In this particular instance, it turns out there was no coverage, and we concede that under these policies for the claims that were made. However,
Mr. Hurley, let me ask you, the meetings that took place before the policies were obtained, your client was required by the U.S. government as a part of that contract to obtain insurance coverage for the transportation of commodities and equipment to be used by the military in Afghanistan. And that's what the discussion was about early on. And so Mr. Harden came up with these policies, that these policies meet the requirement of the U.S. government for the transportation of its commodities and equipment.
Ultimately, the policies were provided to the U.S. government, and ultimately the U.S. government approved the contract for Vanquish Worldwide to do this work. As we read the policies and as some of the preliminary positions of the defendants worked out, it appears that the defendants would have contended that the work being done by Vanquish in Afghanistan would not have been covered under the policies in transporting equipment, trucks, and other things.
That it did not meet the requirements for the transportation of commodities and equipment. Is that what you said?
The positions initially taken by the defendants in this case was that the insurance afforded by these policies would not have covered international activities by the plaintiff.
Okay. Let me ask you further. Let's assume that Mr. Harden did misrepresent. What are your losses here, if any?
Well, and that's an excellent question. The losses, first of all, the easiest answer to that is that the plaintiff incurred approximately $900,000 in costs of defense in defending claims based on the representations of Mr. Harden that there would be insurance cost coverage afforded. In other words, that cost of defense would be available under these policies. So upon being told that, after reporting the claims to Mr. Harden, of course, they were also told that there was coverage if needed for the claims as made by Mr. Harden. He admits that. However, in addition to the cost of defense, there was also ultimately settlement paid out in the amount of approximately $6 million, a little over $6 million by Vanquish worldwide.
But Mr. Hurley, is that a loss, or is that an expense that was owed by your client, which is not a loss? That's just an expense of doing business.
Yes, and as I started to say, whether there should be coverage for that $6.5 million is a separate issue from the cost of defense. And I do concur that the 6.5 number would be a cost that ultimately Vanquish paid to deal with the claims that had been brought.
But that was not a loss for your client. Is what your client owed Sadat Transportation, isn't it?
Well, that's what Vanquish agreed to pay Sadat. Yes.
Okay.
Much has been made in this case of the Bill Brown decision, and the defendants have taken the position that the Bill Brown decision effectively should be disregarded by this court. That's a Supreme Court decision, which basically provides that in instances where an agent engages in negligent misrepresentation in a insurance matter such as this, that the agent and the companies can be held liable for those misrepresentations. The defendants seem to argue that because there was language in the policies that essentially said that the agent could not change or alter the terms and provisions of the policy, that the insured should be precluded from making any claim as a result of that provision in the policy. In fact, Bill Brown in that decision specifically talks about such language that might be inserted by insurance companies into their contracts that would effectively attempt to insulate or immunize the defendants from anything that an agent might say or misrepresent regarding coverage, claims, or other matters in the insurance contract between the parties. We believe that a close reading of the Bill Brown decision and a close reading of the cases cited by the defendants, and I would mention that the cases cited by the defendants include a Eastern District United States District Court decision and 2 unreported cases of the Tennessee Court of Appeals. But I would submit that a very close reading of all of those cases would lead the court to a conclusion that the principles set forth in Bill Brown still are alive and well under Tennessee law. And further, that to find that Bill Brown is no longer the law in the state of Tennessee would essentially, based on the arguments made by the defendants, provide absolute and total immunity and immunization to the insurance companies and even to the agent who is making these misrepresentations on the part of these companies, would allow them to sell this coverage under terms that are not correct and coverages that are not available under the policies, to represent to insureds that there is a cost of defense when in fact they're taking the position that there is no cost of defense. And their interpretation of these cases would leave the Bill Brown decision of no effect and would provide an insured who has been the recipient of misrepresentations and untruths no remedy whatsoever in order to be able to address those. So we would assert that the Bill Brown case is alive and well, and we would respectfully assert that those decisions cited by the defendants in this case would not be binding on the court if the court did believe that they were totally contrary to the Bill Brown principles. We simply believe that Bill Brown should be found in this case to continue to be the law. And we respectfully believe that there is a material issue of fact, and that is whether or not the insured reasonably relied on these representations by the agent. And we believe that all of the defendants should be required to undergo that factual analysis at the trial court level.
Thank you, sir. You have your rebuttal. Who'll be arguing first?
I will be, Your Honor.
Right ahead, Ms. Feldman.
Good afternoon, Your Honors. My name is Seth Friedman from the law firm of Lewis, Brisbois, Bisgard, and Smith, and along with Josh Bond from the law firm of Hodges, Dowdy, and Carson, we represent Sentinel Insurance Company in this matter. This case can really be distilled down to the fact that Vanquish wants insurance coverage under a general liability policy for its admitted intentional failure to pay its subcontractor. In fact, the arbitrator found that Vanquish was liable for breach of contract, conversion, fraud, and breach of the implied covenant of good faith and fair dealing. Furthermore, Vanquish admits that there's no coverage under the actual terms of the policy and that there's no commercially available policy that would have provided coverage for these claims here. He wants the court to create coverage under an equitable estoppel theory pursuant to Bill Brown because Mr. Hardin allegedly promised, quote, full coverage. This theory fails as a matter of law because Vanquish has failed to prove reasonable reliance on any statements by his agent. The policy specifically says it can only be changed by an endorsement issued by Sentinel. Tennessee courts have consistently refused to apply Bill Brown in situations like this one. And even if Bill Brown could apply here, estoppel is not a proper remedy to completely rewrite policies. Bill Brown and his progeny all apply when there was coverage sought for a commercially available product that there would have been coverage for, but for a technical mistake by the agent. There was no mistake here. And let's be clear, Vanquish never asked for insurance for its intentional refusal to pay its bills and operating expenses, which is what they're seeking coverage for. They asked for coverage for, quote, contract administration and accounting. It is not reasonable to think that you have coverage for an intentional refusal to pay your bills when you didn't ask for that coverage. If Bill Brown applies to these facts, it would upend the insurance industry in Tennessee. There'd be no point in having a policy. Insureds would just claim their agent promised them coverage for everything. And it would lead to some absurd results. For example, there could be coverage for murder under a CGL policy because the insured was promised coverage for injuries caused by the insured. or there'd be coverage for arson under a first-party property policy because the insured was promised coverage for fire damage. This is not Tennessee law. Estoppel is not favored, and Vanquish has the burden of proving every element of estoppel. Now, courts applying Bill Brown have held that it's not reasonable to rely on agents where there are statements in the policy that can only be changed by the carrier. It's usually called a changes condition. And here in the Sentinel policy, it says this policy's terms cannot be amended or waived, can be amended or waived only by endorsement issued by us and made a part of this policy. And as Mr. Hurley alluded to, there are several cases where they have said that that language means that there's no reasonable reliance as a matter of law. I think a great case is the Builders Mutual versus Pickens out of the Eastern District of Tennessee. And that case is fairly close to here in that the insured agreed in that case there was no coverage under the actual terms of the policy. They just said the agent said we had full coverage. And the judge in that case said no, under the changes condition, that ended any discussion, and Bill Brown did not apply. Same with Fincham versus Patterson, and the Tennessee Court of Appeals held that a commercial insurance policy with a theft exclusion still was in force, and no statements by the agent would matter because of the changes condition in the policy. Court said it was unreasonable as a matter of law to rely on the agent in that situation. Also in Reed versus National Foundation, this court, Tennessee Court of Appeals, held that the changes condition prevented the application of Bill Brown, where a health insurance application said it was not effective till the policy was issued, delivered, and a premium paid. And the agent, and it also said the agent could not alter or change the coverage. The insured claimed the agent had assured him of coverage, but the Court of Appeals said Bill Brown did not apply there either. So there's a consistent line of cases doing this. And here, there is just no reasonable reliance because the policy says the terms cannot be changed, and Vanquish is deemed to have read the policy under Tennessee law. Again, Bill Brown applies where there would have been coverage, but for some technical mistake of the agent. And that's not the case. To the extent that Vanquish claims it would have done something else or gotten another policy or self-insurance, that's a red herring here. The plaintiff had been operating under the NAT contract for the U.S. government for over a year before it got the Sentinel policy in 2012. So they'd been operating since 2011. So that doesn't make any sense. The bottom line is you can't create coverage where none ever existed. And briefly, I want to talk about the respondeat superior claim that is raised by the Vanquish in this case. It's really just their estoppel argument restated. Hardin had no actual or apparent authority to act on behalf of Sentinel to change the policy terms here. The contract between Hardin and Northeast Agencies, which is Sentinel's broker that helped issue the policy, said Hardin had no actual authority. This is all in the record. And there's no evidence that Hartford gave apparent authority for Hardin to say there was coverage for any of these claims either. Vanquish has pointed to zero evidence in the record that anything that Sentinel said that said Hardin could change anything that's in the policy. And further, to the extent they've cited to TCA 56.5 115B, 115, Part B of that statute specifically says the statute shall not affect apparent authority of an agent. So the apparent authority isn't there. There's no actual authority. There's no apparent authority. Therefore, there can be no respondeat superior to Sentinel in this case. The bottom line is Bill Brown is not a panacea. Vanquish wants coverage for its intentional refusal to pay its bills. No policy can or would provide coverage for this claim. And Bill Brown does not apply because Vanquish did not reasonably rely on its alleged assurances by his agent Hardin. Therefore, we respectfully request that you affirm the trial court's judgment. Thank you.
Yes, sir. Okay. The next part, Ms. Sims, is that it?
Yes, sir.
Right ahead.
All right. Your Honor, Vanquish had a subcontract with Sadat to haul materials in Afghanistan. And disagreements arose because Vanquish began withholding funds that it received from the federal government, to which Sadat alleged that it was entitled. Vanquish said it was withholding the funds in order to recoup amounts that it had allegedly overpaid to Sadat to provide it financial assistance, as required by the subcontract. SADOT filed its original arbitration against Vanquish in December 2013 and its amended arbitration petition on January 29, 2014. The arbitrator then proceeded to enter two awards, a partial award dated May 13, 2015, and an interim award dated February 25, 2016, in which awards Vanquish, the arbitrator found that Vanquish had breached its contract with SADOT and committed conversion of funds in the amount of $6.5 million. And Vanquish admits that it withheld $6.5 million from SADOT. Vanquish and SADOT then subsequently entered into a settlement agreement where they settled for $7 million, although the arbitrator had found $6.5. And in that settlement agreement, both of them disingenuously agreed that neither of them had committed any wrong or fraud or any other kind of wrongdoing, despite the fact that they alleged to the contrary in both of their claims against each other before they were arbitrated. As a part of the settlement agreement, Vanquish and SADOT stipulated to the vacating of the partial award and the interim award. But now Barton claims that the awards no longer exist since they stipulated to their vacation. This position on the part of Barton is in violation of the holding of the case of Watermark against Morristown Management, which is a Sixth Circuit Court of Appeals case. That case held that awards that are vacated as a part of a settlement do not lose their preclusive effect. In other words, under the doctrine of Watermark, the awards that were handed down by the arbitrator finding that Vanquish was guilty of breach of its contract and conversion are still have preclusive effect. Vanquish filed its complaint against the appellees in this case on January 13, 2017. And in the complaint, it alleged that ANPAC and Hartford had wrongfully denied coverage in the case, and that Hardin had misrepresented matters to Vanquish concerning the type of coverage it had, i.e., Vanquish claimed that Hardin told them they had, quote, full coverage, close quote. The appellees filed a motion for summary judgment. The trial court found that there was no coverage under the Hartford policy or the ANPAC policy because there was no occurrence or accident and no property damage or personal injury. Vanquish, in its appellate and reply briefs, now agrees that the trial court was correct in finding that there's no coverage for the matters for which SADOT sued Barton in the arbitration. Therefore, this appeal gets down to the fact that it revolves around the cause of action which Vanquish filed against Hardin, alleging negligence and misrepresentation, i.e., that it had full coverage, and claiming that Hartford and ANPAC are liable for Hardin's negligence in not procuring proper coverage.
Let me ask Mr. Sims.
Yes.
Did Hardin secure insurance coverage for the transportation of commodities and equipment in Afghanistan for Vanquish?
To my knowledge, it did not, but I cannot say for certainty because that issue has not really come up. It's a side issue.
Well, Vanquish is arguing Hardin said they had full coverage. And the idea of getting insurance coverage was to satisfy the U.S. military that there was insurance coverage for any claim really that the military could make if their equipment or commodities were lost. And what I'm trying to figure out, Did either one of these policies provide that coverage, or did Mr. Harden misrepresent that?
Well, Your Honor, there's expert testimony in this case that there is no policy on the market that covers breach of contract or conversion. And this wasn't an accident that
That's not
occurred.
my question. And I realize that. But was there coverage that would have protected Vanquish if the material that it was transporting through its subcontractor was lost or damaged during the transportation of that equipment? Was there any coverage for such a loss?
Well, I don't know. And your first question was, did ANPAC supply that coverage? I don't have any information that it did, but that issue has not come up at all in this litigation.
Okay.
And so now we get down to the fact as to whether or not there was a reasonable belief in Harden's alleged representation that they had full coverage. And I would suggest to the court that nobody could reasonably believe that a breach of contract or intentional conversion could be covered by insurance.
Yes, sir. Mr. Kingsman?
Yes, sir. Thank you. My name is Mark Kinsman. I'm with Randy Kaiser, Revere and Bell, and we represent Steve Harden in Harden Insurance Services. As Mr. Hurley mentioned, the issue is just one of the issues is justifiable reliance. The court found that Harden had negated that element of the plaintiff's cause of action when the court found that there was that the plaintiff had no reasonable belief that coverage was provided under these policies, that any such belief was not warranted. Justifiable reliance is not available or is not shown where the means of information are equally accessible to the plaintiff, so that if the plaintiff, using ordinary prudence and due diligence, might on their own discover the material facts. In other words, the plaintiff is required, Vanquish was required to rely also on its own due diligence and prudence. And if they failed to do so, they're bound by those consequences. Here, the court found that the alleged reliance by Vanquish is not warranted because it had possession of the policies, and it had those policies for a number of years and had renewed them. As Mr. Hurley said, Vanquish was charged with knowledge of the contents of those policies. If Mr. Barton utilizing his employee with the insurance agency he owned had reviewed those policies, he would have known that he had no coverage for these matters. And one of the facts relied on by the court, one of the findings of fact by the trial court, was that Eric Barton, the principal of Vanquish, owned an insurance agency that sold commercial general policies like these. And one of its employees, Brian Abercrombie, was one of the witnesses who testified that there was no such coverage available. The other point I think the court may have relied on was that Mr. Barton was definitely a sophisticated businessman. If you look at the government contracts that Mr. Barton signed and that he administered and took care of, those are substantially more complicated than these commercial general liability policies. Mr. Hurley made the point that these were long, complicated insurance policies. Well, they're nothing compared to those contracts Mr. Barton normally dealt with as part of his business. The other point is Tennessee Code Annotated Section 56.7.135 provides in subpart B that where the premiums are paid for the policy and where the policies are renewed, that creates a presumption that the insured has accepted that coverage. Here, that happened. Mr. Barton and Vanquish paid their premiums on these policies. They obtained the written policies, had a chance to review them, and accepted that coverage. They're deemed to have accepted the coverage provided under 56.7-135. All of these facts show that Vanquish, any alleged reliance by Vanquish on the statements by Steve Harden was not warranted, as found by the court. The other point I'd like to make is that, and this has been made by other counsel, that the specific coverage that Mr. Barton and Vanquish asked Steve Harden to obtain was coverage for accounting and bookkeeping errors, something like errors and omissions coverage. Well, that is absolutely not what happened here. That's not what this arbitration is about. If the court would look at the trial court's findings of fact number 19 and 20, both of those describe the conduct that Vanquish engaged in. It was absolutely intentional conduct. It was fraudulent conduct. It was conduct that would not be covered under any policy, and any reasonable person would not expect to have coverage under that for that kind of conduct. And so to argue that Mr. Harden should have foreseen that that was the kind of coverage that Vanquish wanted is unreasonable. And it's also, there's no causal link between the alleged representation by Mr. Harden that everything will be okay, you've got coverage, don't worry. If he had coverage, it would have been for bookkeeping errors, not for this kind of conduct. And so there's no causal link between those alleged misrepresentations and the damage that Vanquish sustained due to its own intentional conduct that wouldn't have been covered under any policy anywhere. Thank you.
Kingsman, let me ask you,
Yes,
what
sir.
sort of coverage was Mr. Harden able to obtain for Vanquish? Because what I'm
Vanquish-
hearing Mr. Hurley say,
Sure.
there was no coverage in the event of a loss in connection with the transportation of equipment, you know, like you had in the Bill Brown case. What coverage did Vanquish have?
Two things. First, Vanquish operated out of Oak Ridge, I believe it was Oak Ridge, Tennessee, and they had an office there where they had staff that basically did bookkeeping work, administering these contracts, emailing people, transferring paperwork and money and this and that and the other. So they had a business operation in Oak Ridge, Tennessee with a building and staff and people. So he bought commercial general liability coverage for that operation, and he bought building or property insurance for that building, workers' comp, and coverage for trucks and vehicles he had in this country. I'm not, to answer the question you asked other counsel, Your Honor, I don't know that the government expected, and I just don't know I'm saying I don't know the answer to this, is whether the government expected Vanquish to have insurance for the property and trucks in Afghanistan. Because what ultimately happened was when equipment did go missing or property was gasoline or whatever came up short, they took it out of the money, the government took it out of the money that it owed Vanquish. That was part of the reason Vanquish did not get paid for a lot of the work that USC did. And that was part of the dispute they had between the two of them. So I'm not sure there was even a requirement under the government contract that insurance be provided for the activities of trucking in Afghanistan, because that was done by USC, a subcontractor. That's who operated that business in Afghanistan, not Vanquish.
Thank you. Any further questions? If there's not, we'll hear your rebuttal, sir.
Thank you, Your Honor. I would respectfully disagree with several of the things that have most recently been said. First of all, the United States government did request insurance, did require insurance, and did ultimately approve these contracts. There was extensive testimony in this case and documents entered in multiple depositions indicating that Agent Harden not only made those representations to Vanquish, but issued certificates of insurance, also known as COIs, that were routed directly to the United States government, affirming that these policies existed and that these policies insured Vanquish Worldwide LLC. And that testimony was predominant through many of the depositions taken in this case and was clear at all times. Secondly, there have been some statements made in the briefs and also in argument today that Mr. Barton, the president of Vanquish Worldwide, owned an insurance agency, and that the knowledge that he had through owning that agency should be imputed against him in this case, in part in helping justify the assertion that he was a sophisticated businessman. What I believe all the parties in this case know to be the truth, because it was the absolutely unequivocal testimony and proof that was produced in this case, is that Mr. Barton purchased and operated an insurance agency years after these events occurred, and testified specifically that he did so because of the debacle that developed based on his reliance on the representations by this insurance agent. So there should be no assertion or underlying concern that Mr. Barton owned an insurance agency when any of these issues were being developed or were underway. The clear proof in that was that he acquired an insurance agency later for the specific purpose of not finding himself in this type of predicament again in the future. The assertion that Mr. Barton and Vanquish were disingenuous for entering into a settlement agreement that provided that neither party would contend that the other had committed fraud, there were counterclaims, and there was not a final arbitration award. There were still issues that were being litigated by these parties. There were still issues that were in controversy, and they entered into a settlement agreement. And any assertion that any party that enters into a settlement agreement that sets forth and states that both parties concede that there are no ultimate accusations being made against the other of fraud or other things, and that to do so is disingenuous, we all in this meeting room today know that that's what settlement agreements provide. And we would simply assert that any statement that it's disingenuous to do that is inappropriate. I end my rebuttal with this. If the position of the defendants that these insurance contracts and that this controversy about coverage and about defense costs and the paying of defense costs was so ultimately clear that no reasonable person could rely on the belief that there was coverage and that cost of defense would be there. First, why would Mr. Barton have posed that question to his insurance agent to begin with? And secondly, why would any insurance agent in the state of Tennessee, if it was that clear, if it was that convincing, if it was that evident that no reasonable person could believe that there was coverage, then why would an agent not say so? In fact, why would an agent not even go further and say, no, not only is there not any coverage for the underlying claims, there is no coverage for your cost of defense. So Mr. Barton, govern yourself accordingly, make all your decisions with the absolute concrete knowledge that you have zero coverage for anything. Instead, Mr. Harden admits that he told Mr. Barton that there was coverage. He admits that he told Mr. Barton that insurance costs, the defense costs would be covered or reimbursed, and led Mr. Barton on a path of approximately a year and a half in defending this case that was unnecessary, and now asks to blame Mr. Barton for relying on the representations that were made to him. And we simply assert in this case that that should not be permitted and should not be allowed. And we would ask that the court reverse the trial court.
Let me ask you, Mr. Hurley, where would I look in the record to find what Mr. Harden was told initially about this claim that was being arbitrated?
I believe this is a big record, and I certainly don't want to misrepresent locations in the record to the court. I believe that there were findings by the trial court in its findings of fact and in the undisputed facts that the trial court set forth that address the initial conversations between the parties. I can also state that in the summary judgment papers that were filed both by the defendants who moved for summary judgment and the plaintiff who responded thereto, there were multiple references and inclusions of deposition transcript testimony that address those discussions. There is also a reference in the affidavit of Eric Barton, which was part of the record that was before the trial court and was part of the papers that were submitted to the court as part of the record on appeal. And that affidavit of Eric Barton also specifically references what the parties discussed and the types of coverage that Vanquish was seeking. And that affidavit was never contested or rebutted by Mr. Harden.
Thank you.
Anything further? I want to thank the attorneys for your presentation. Your case is now submitted to the Court of Appeals for resolution. You will receive our opinion within a due course of time. I can't say exactly how long, but within a due course of time at this point, okay? If there's nothing further, Mr. Clerk, will you place the court in recess, please?
This honorable court is now in recess until 3:30 p.m.
Thank you. The attorneys may be excused.
Thank you.